It is June 22nd of 2026, and this is the Court Gallery. We start with a probation revocation hearing that leaves Judge Stevens speechless. The woman on probation for striking her own child with a firearm now works as a city bus driver, and her list of new violations is extensive. Then, we witness the heart-wrenching sentencing of a mother whose failure to seek medical care left her 5-month-old infant with catastrophic, life-altering injuries. And finally, a civil hearing that proves no good deed goes unpunished, where a simple dispute over abandoned kittens escalates into drawn firearms, conflicting stories, and a very confused judge. It all starts right now.
Where are we going on this? She's on the for a second-degree felony, right?
Right. Today
Come on up, please. We call 20-33873 Alista Adams. That you, ma'am?
That's right.
That's you? Okay, there is a motion to revoke probation filed June 5th of 2026. This just got filed. Are you ready for that today?
No.
Okay.
What I had sent the email and asked Mrs. Ailey for was to just give me a hearing on a bond for her, but she is gainfully employed.
Yeah, I brought up on it.
Right. She's gainfully employed, Judge, and with it being a deferred, I was gonna ask the court to set her a bond. And she has
What I'm looking at, or it is my probation memo, administrative hearing filed, signed on June 3rd, ordering a motion to revoke probation that has now been filed
Yes, sir.
very quickly. And it's alleged she committed new offense of evading arrest or detention and assault on July 24th, darn, a year ago. Failed to report as directed on May 26th. Failed to notify probation of the arrest. Failed to maintain appropriate conduct during an office visit on May 28th by appearing in inappropriate attire, arguing with the probation officer, and attempting to audio record the interaction using a cell phone.
No, sir.
Are you gonna let me finish before you rudely interrupt?
Yes, sir.
Okay. Further failed to complete court-ordered probation hours, restitution hours, remains delinquent on court-ordered financial obligations, has an outstanding balance of $2,505 on costs and other payments required, is in arrears $1,680, and continues to fail to comply with multiple conditions of probation and appears no longer amenable to community probation without further intervention by the court. Let me look at this pre-sentence report. You were placed on aggravated, deferred, or unadjudicated probation for aggravated assault. Officers met with a victim, a 15-year-old, advised she had been assaulted by her mother. Okay. Large swollen area in the front of the child's head and a small laceration in the center. Victim stated her mother, and sister got into a verbal argument which caused her mother to produce a handgun and start kicking everyone out of the house. As her mother was pushing her out of the house, she was hit in the head with the handgun. CPS was called to the scene and took custody of Senegal. Later interviewed at the North House, where she reiterated that her mother struck her with a handgun in the head. Say your probation's the misdemeanor history. There's 30 days in jail back in a long time ago for resisting arrest, driving while license suspended in '05. Discharge of firearm in the city, 1 year deferred probation. Aggravated assault here. Okay. So. What you want to do today?
Judge, I had asked just today, just for a hearing to give her a bond. So she.
What's your bond right now? Nothing?
Nothing, it's
Okay.
nothing. And she's
He's
gained
on the
employed
floor.
by the city of Beaumont, like,
Beaumont too.
huh?
Beaumont too.
Beaumont has it, right?
Beaumont Transit.
Yeah, right. Judge, she's a bus driver for the city of Beaumont. She's a bus driver for the city of Beaumont. And I just wanted to ask the court to give her a bond so she can continue her employment. She's not having any problems with the city. And in my understanding, her supervisors and everybody want her back to work to help drive the buses and get people where they need to go, right? And she's definitely not gonna be a flight risk or anything like that. And we were just asking for a reasonable bond for her today. At least so she can return to work. And then I'll get to working on the evading arrest judge, which is in Judge Wood's court. And I think the clause number of that is 25 CCCR 2253. That new case, I'll begin working on that and take care of that with the misdemeanor prosecutors. So I'll try to deal with both this one and.
That's okay. It's just still in this court for this, what I'm concerned about.
Right.
Whatever you do out there is your business.
Right.
But there are 8 violations here. And once again, let's see. The assault Class C misdemeanor, July 24th, is arising. I don't have any, I really don't.
He's saying that case was dismissed, is what she's telling me.
Huh?
Yes, yes, sir.
She's telling me that the case, I haven't confirmed that, but what she's telling me is the case was dismissed.
It can be dismissed all day. It doesn't, but it's still in my court, and then I get to decide. It can be dismissed. It's not that there's, as long as you commit the offense, I don't care if a Class C is dismissed somewhere else. It's my call.
Yes, sir.
I get to make my own decision whether you committed the crime or not. It's not whether you've been charged or not. It's whether you've committed the crime, and we got to deal with that in a different way than in a pending case. And I don't see anything about that. I don't see
I don't have anything
detail
on
about
that today, Judge.
What is the Class C assault all about?
The office reported just says that she hit a family member in the back of in front of the police officer.
She did what?
She hit a family member in the
Who
back of the head. I
was
think it was her nephew.
Your Honor, those are facts we can develop if she chooses not to enter a plea of true to that in the motion or vote.
And then we've got this evading arrest or detention. What's the status on that? That's pending?
Pending, Judge, showed that that was actually filed back in September of 2025, but she wasn't arrested on this until May, so that means she went over a 6-month period with a warrant outstanding without resolving it. She was
Yeah.
arrested when she showed up for this administrative hearing.
Okay. Go ahead. What are you asking for?
Just, with her being gainfully employed with, and she said that, right, with the city judge and to help with her, legal expenses, because I am retained on this case. I was hoping that the court would, let my client return to work so she can meet her other obligations with me as well as to her family. And, while she's incarcerated, I know she's not going to do that. And she'll tell you that she's not gonna be a flight risk or anything like that. You will come to court, right?
Just,
And I'm not asking you about the underlying offenses, but I am asking you, you are gonna come to court, right?
I,
And you do have a job, because Judge Wood, I don't want to misspeak. So you do have a job, right?
I do.
And you drive people around city of Beaumont, you work for the city of Beaumont, gainfully employed by the city of Beaumont, right? And they are trying to get you back to work to get to your routes, as I understand it, right? And you're not gonna be around anybody that's gonna be using drugs, fighting, or acting anywhere that's unruly. You're not gonna be around any bad people, are you?
No, sir, I don't use drugs.
All right.
Hold on. That's what she's alleged to have done.
No, I'm talking.
She's alleged to have evaded arrest or detention and committed assault.
No, I'm saying while she's out, I don't think she's.
I'm talking about when she was out on my probation and she's alleged to have done this. What difference was letting her out on bond do? Yeah. That's bothersome to me,
Mhm.
especially in light of the fact that you're on probation for striking a child with a gun. How about that? That's pretty serious. I mean, who
Right.
does that? The victim in this case, what was the relationship of the victim to the defendant?
I think it was her daughter.
Yeah, a daughter. A daughter. You're shaking your head?
Uh,
You pleaded guilty under oath to it. Are you not guilty? I want to know because you pleaded guilty under oath, which would be perjurious if you lied to me
I pleaded guilty, yes, sir.
because you were guilty. That's what your document said that you pleaded under oath to. Are you taking that back?
No, sir.
I'd want to know because you want to add perjury to all this mess. I'd love to hear more. Who does that? What kind of person strikes your own child with a firearm? In the head? Yeah, good Lord. But you're driving a bus around town? Well, none of the customers complain about what they're being charged. I'm afraid the way you deal with that. But here we are, allegation number 2 is committing the offense of assault. And what was the nature of that allegation?
It said that the offense report stated that she hit a nephew in the back of the head in front of the police officer.
Hit the nephew in the back of the head with what? Her hand?
Her fist, yes.
That's going to be likely going to be on body cam footage from that offense, Judge.
Good Lord.
So whether it's dismissed or not, the state feels like
You're on my
prove
watch
it.
here. And you're allegedly assaulting people on my watch. You're supposed to be following the rules and then evading arrest or detention. Failing to report. How many times she failed to report? Just once?
Well, since she's been on probation, it's been a total of 14 times.
What?
It's been a total of 14 times.
14?
Yes, Your Honor.
I didn't know anything about that. That's news to me.
You ain't getting a bond.
Sir,
You're not getting a bond because I've just heard you don't report. And when I'm ordered you to report regularly, she says 14 times? Are you kidding me?
Called and rescheduled you under. I've never missed reporting. I've called and rescheduled. I did not have not come.
All right.
I've called a few times to say that you aren't, and with that assault charge, it was someone at my house that it was my niece and her husband was there. He was drinking and she did not want to give him the keys to the car.
Why did you strike your child in the head with the gun to begin with? Why did you do that, ma'am? that you're on probation for. Why'd you do that?
She said it was a gun. I did not, it was during, she said it was a gun. I had a knife and cut my own tires. They stole my car. They stole her car.
Okay, I want you all to look into perjury. If she stood up before me and swore
I
that
didn't say that. I didn't plead
that
guilty.
you pleaded true to intentionally and knowingly and recklessly causing bodily injury to the child by the use of a deadly weapon, namely a firearm, by striking the child in the head with said firearm. Did you do that or not?
Sir,
Okay. So what's all this, the last 2 minutes? What were you explaining to me that you didn't? Okay. Your bond is $50,000 plus a GPS device. You have to have that and you have to be at home confinement, but you can't have any contact with the victims of any of this. Do you understand? Just keeping you from making mess is hard. I want this hearing in 3 weeks.
Just with her home confinement, will she be able to go to work though, even though she's at home?
Yeah, as long as to and from in the most direct route possible. I guess the city knows of her illustrious criminal history.
I don't know the answer to that question.
Since she didn't report her original arrest to the probation department, I'm going to guess that they do not know, Judge.
that did not happen.
I'm sorry. I'm sorry you interrupted. He was speaking. You just can't follow any of the rules. This is just a quorum. I know, I get the sense when you're around your family, you're the boss and you dictate to people. It's on your terms. That must be an interesting household, but it sounds inconsistent with the kind of home life I'm used to, where it's a loving, harmless familial relationship where each person respects each other. Meanwhile, you're striking your children with a firearm in the head, which is a second-degree felony. You're on probation. Pardon me. You're back in front of me. All right. Can you be ready in 3 weeks?
Yes, sir. This one's
With
manageable.
this thing
Yes, sir.
fast. Thank you.
Thanks, Judge.
All right. Anything else, Langston?
Uh,
Anybody else?
I think that's all my people that I'm aware of, unless
We now recall cause number 23 CR 203, the state of Texas versus Asia Kiani Young, who is present with her attorney, Mr. Turk, and the state's attorney, Mr. Hamp, are present. Earlier, the defendant pleaded guilty to injury to a child with intent to cause serious bodily injury. This is a first-degree felony under our law. That was what she was indicted for. She later pleaded guilty to a lesser included third-degree felony of injury to a child. Is that what it was?
Well, Judge, we actually, in prior proceedings, the indictment was amended on the record to reflect a third-degree felony.
Okay. In lieu of causing serious bodily injury, as it was earlier indicted, the defendant pleaded guilty to intentionally and knowingly by omission causing bodily injury and mental deficiency to the child 14 years of age or younger.
Correct, Your Honor.
That's so under section 22.04, subpart A, subpart 3 of the Texas Penal Code, a person commits an offense if the person causes bodily injury to a child and an offense is a felony of the third degree when the conduct is committed intentionally or knowingly. Everybody agrees it's section 22.04, subpart A, subpart F. Gotta look at
Yes, sir. That is the proper punishment.
And the agreement here under this third degree felony is whatever sentence shall not exceed a cap of 8 years confinement in prison. So we're looking at no less than 2 nor more than 8 years confinement. Deferred or unadjudicated probation is an option. And I think regular probation is also an option as well. 3 different options are available. Has the court had have the parties had an opportunity to review the pre-sentence report that has been prepared by the probation office? And are there any corrections or changes to it, State?
State has, and we have no objections or changes, Judge.
Defense has read it and we have no changes, Judge.
All right. Statement open and closed. And also, did y'all have a chance to read? There were some letters that have been sent and to the court. I want to three of them.
Some of them are.
Or looks like from our family members because they were looked like they were typed on the same
They were emails to me, Judge.
same device. Then you've got 2 other letters that have been submitted to the court on behalf of the defendant. All right.
So I am going to open and close on this one, Judge. Just in fairness to Mr. Turk, I want the record to be clear that what I'm asking for is the 8-year cap on this. I feel like leniency and all that was addressed when a prior prosecutor adjusted this lady's charge down from a 1st degree to the 3rd degree. I want to point out before the court moves into listening to other comments that the co-defendant on this matter received 35 years. And that was a negotiated settlement at the time of trial docket when the exposure could have been higher. I mean, it was obviously a 1st degree felony, but that sentence is just and proper and addresses the actual serious bodily injury that was done to this child. So with those comments, I'll wait to make the rest of my argument in response, Judge.
Okay.
Judge, what Mr. Dylan Banks Sr. did to the child, he was the one that actually committed the injuries to the child when Mrs. Young was not present. No one, and to include Mrs. Young, is trying to justify her delay in seeking medical care or excuse her delay in doing so. She has been remorseful. She is pled guilty. She is taking ownership of this. She voluntarily, if I understand correctly, spoke with the police and admitted that she apologized for what she did. She said what she did was wrong. But she was not the one that physically injured the child. She's the mother. She did delay in getting medical attention as she's pled guilty to. But she did eventually the child eventually got medical care.
How?
At Children's, I think they
Texas Children.
Texas Children.
How did the
I
child
think
get
they, you called and
Yeah.
when?
probably several days later.
First of all, what's the status of the other defendant?
He received 35 years.
And for the court's edification, Mrs. Young and Mr. Banks Sr., their parental rights have been terminated.
Mm-hmm.
And my understanding is the child, from what I saw in the PSI, the child has been adopted. Mrs. Young does have 3 other daughters, 2 of which have submitted letters to the court along with her ex-husband. The father of those 2 daughters, all in support of Mrs. Young finding leniency from the court. There's 2 other letters from Ms. Martin and Mrs. I apologize. Warren, sorry about that. and support her, kind of detailing her Mrs. Young's past where she's had abusive relationships. She's had bouts of homelessness. Her parents had issues with mental health and whatnot. She's had a tough life, Judge, and she's tried to manage. And then the other letters say that she has been a caring mother. They haven't had any issues such as this. My understanding is that Mr. Banks Sr. was an evil person, to put it lightly. He manipulated the family and did things that were just evil. And that's not to excuse what Miss Young did. She's not seeking, she's not here. She's just simply asking the court to take into consideration that she has no criminal history. This is not who she is, but she's willing to take ownership of it and whatever remedy the court finds appropriate. She's willing to take parental parenting classes. She has had a history of cognitive issues in the past. She does understand what's going on here, but she would ask the court to grant her probation, deferred preferably, so that way she could get back to parenting, taking parenting courses to improve her parenting skills, and improving her relationship with her family. And that since we have a history of in the court looking at people's past for harsher sentences, I think we should take a look at her history for the fact that she doesn't have that baggage that some people that come through this court do. She has not been a problem in the court, as had been demonstrated by several other cases of recent note. But she is indeed remorseful of what happened. But she wants to move forward if possible with her life, but understanding that what she did was wrong.
I don't know. I would assume.
All right. Anything else?
No, Judge.
Did you want to say anything, man?
No, sir.
Okay. Go ahead. Stay.
Yeah.
All right, so clearly, we're only going to hold this lady responsible for her conduct. And as the indictment is here, it's all about her omission. She admits to police officers that she knew that the child had been injured and didn't act. Every minute that goes by impacts someone who's suffers serious bodily injury. And this situation was no less than 2 days, but could have been up to a week before the incident. So to label the other co-defendant as a monster and was responsible doesn't necessarily accept the responsibility for the parent of the child, who has the responsibility to do more than what she did. She did nothing whenever she knew that her 5-month-old child was suffering. That conduct in and of itself warrants prison time and does not warrant probation. One thing of note in reading her family support, which I'm glad she's got family support. It's a good thing. The court notes that often we stand in here and we don't see that. What I note in reading all of these letters is not one word is mentioned of Dylan Banks Jr. That's the name of the child that is the victim of this. Nobody offers sympathy. Nobody offers care. It's all about her. And to some degree, you can understand it when it's the individual. But the bottom line is she's responsible by her lack of conduct for the resulting injuries that this child has. The grace given to her, the lenience given to her was to say it wasn't serious bodily injury, and it clearly was. That changed her dynamics. It dealt with the fact that she has no criminal history. And although the state wasn't aware of her history, Nothing in that history about what's happened to her warrants this. It doesn't minimize it. It doesn't help explain it. In fact, if anything, the fact that she had bad treatment as a child should have made her more on edge to where she would do the right thing for this child, which she did not. And I probably will be repetitive about the fact that Dylan Banks Jr. is not mentioned by anybody, and he is the victim in this. When I read through this report, I agree with, and I probably should have led off with the fact that the officer, when they get down to this recommendation, says that the seriousness of this offense warrants a significant consequence. That's as close as I've ever seen in my 36 years of practicing law, a probation officer saying that they need to go to prison. Often what we'll hear from the other side of this bench is because they write the potential terms of supervision that they're recommending probation. They're not. They're just telling Your Honor what should be done if we get there. Another glaring fact that does not help Ms. Young at all is when we look at page 2 under her family structure, she suggests to the interviewing PSI officer that she's got living arrangements. So being a good officer, that person goes and checks. That individual has not been talked to at all, is not one of the supporting letters, is not somebody that said, hey, yeah, I'm ready for her to come live at my house. I started out saying, and I'll end with saying, what happened to Dylan Banks Jr. warrants a prison sentence, and in my suggestion, it should be a term of 8 years.
All right. Anything to add? By anybody? No. No. Okay. The court is making some changes that need to be made in the documentation in the pre-sentence report. The indictment is before the court from the pre-sentence report with the pre-sentence report, but it does not have the corrections where the indictment was corrected from a first-degree felony to a third-degree felony. And also deleting serious bodily injury versus bodily injury. And all of that is for technical corrections in this report. Because the defendant was initially indicted for a first-degree felony, it was later reduced to reflect a third-degree felony of injury to a child rather than serious injury to a child. And that the change of intention to intentionally and knowingly in the culpable mental states to cause bodily injury and mental deficiency versus serious bodily injury or serious mental deficiency were corrected and amended by the agreement of the parties, which changed this punishment range from a first-degree felony to a third-degree felony. This is why, and then the resulting agreement of a cap of 8 years. what is brutally honest about the facts of this case is that a 5-month-old infant, the defendant's child, on January 20th of 2023, and this is now 3.5 years ago, was brought to Texas Children's Hospital in Houston by the defendant and Dylan Banks Sr., who were the parents. And the evaluations from the Children's Hospital revealed that the child had suffered serious injuries indicative of abusive trauma, which included multiple rib fractures, brain bleeding, brain tissue damage, bilateral retinal hemorrhaging, bruise to the neck, potential spine injuries, and was suffering from seizures. This was deemed critical injuries. The child was placed on a ventilator shortly after the admission, and then Child Protective Services and the Houston Police Department were alerted. And during the investigation, Banks' father admitted to shaking the child on January 13th, which would have been a full week before the child was brought to the hospital for care. And when this defendant was interrogated by and questioned by authorities, the defendant acknowledged her awareness of the abuse inflicted by the father, and that he had texted her around January 18th, which was 2 days before the child was brought to the hospital, claiming that the child had stopped breathing, but he had revived him. And despite learning of signs of distress and bruising on the child, Asia Young, this defendant, did not seek immediate medical help or report the abuse, and claimed that she did that because she was in fear of the injuries being discovered by the authorities on the child. And consequently, it was determined by the investigators that the defendant had intentionally or knowingly caused serious bodily injury to the child through her inactions and failing to fulfill her legal obligation to provide necessary medical care. But that charge was later reduced by agreement by the parties to bodily injury rather than serious bodily injury. According to the recommendations from the probation office in the preparation of the pre-sentence report, it was summarized that given the nature and circumstances of the offense, the significant harm suffered by the victim, and the defendant's failure to take appropriate action despite having a duty to protect the child and obtain medical care for the child, the officer believed that the seriousness of the offense warrants a significant consequence. And truly, who wouldn't? This, once again, I'm like deja vu all over again with an infant child barely out of the womb, 5 months old infant, suffering severe injuries, and then the people who were responsible or knew about it and were responsible for action hesitated and delayed. And thus, by failing to act, caused more of a dangerous predicament to the child who in 5 months is literally helpless to take care of itself, but must rely on our creator and our nature, and the nature that allows the parents, the responsible parties to the birth of the child, to assume the responsibility of proper care, which was not done in this case. I don't believe anybody contends that this defendant had anything to do with actually directly harming the child. Isn't that right? I don't see anything in those four corners. But days went by before the child was brought to help. And that is a parent's responsibility, in spite of the other parent being viciously responsible. And that's what resulted in his 35-year sentence. Now we're dealing with someone who may not have had direct contact with the harm of the child in the harming of the child, but yet had a natural and creator given responsibility and a lawful responsibility to seek emergency care as soon as possible. And that delay put this child into harm's way, greater harm's way, by continuing to suffer those serious bodily injuries. I mean, a child can't go along with brain bleeding and multiple rib fractures and brain tissue damage and retinal hemorrhaging. And those are going to ultimately probably result in long-term disabilities for the child during its life. So that's where we are on that. Anyone add anything? State,
No, Judge.
defense,
You've summed it up.
Okay.
ma'am, you want to say anything else? If nothing further, I'm going to find that Asia Young, the defendant in this case, has pleaded guilty to the 3rd-degree felony of injury to a child. Voluntarily, you have pleaded voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at this guilty plea hearing, which admitted responsibility under the law to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this 3rd-degree felony of injury to a child. And I'm following this agreement. You were hereby sentenced to confinement in the institution of division of the Texas Department of Criminal Justice to serve a term of 8 years confinement. A parent has a very special obligation. This is a duty. And you delayed, knowing that the child was injured. And the child is lucky that the child did not pass away, but we can all use reasonable thought here under these injuries that the child may very well suffer long-term, if not lifelong, harm from the delay that was caused because the responsible parties did not either act correctly at the beginning or did not seek medical care when the parent was aware that the child needed help immediately. Child is helpless with their 5 months old. That's why the parent's duties are strict under the law, and the law provides serious penalties when the parents do not act responsibly. This court finds that under these circumstances, the sentence is fair and appropriate, and also sends the message that a 5-month-old, all children's lives are not only important, but are dependent upon, and their well-being are dependent upon the parents, the caregivers' responsibilities to deal with any problems immediately and responsibly. And this child was not dealt with properly, as a parent should deal with child's injuries. Thus, this court finds this to be a just sentence under these circumstances. Anything else?
Okay.
That is all. We are in recess on this case.
All right, and next we've got case number 26-284, Valerie King and Adrian Boyce versus Zachary Vassar. All right. So
Yes, Your Honor.
All right, so I already went over kind of the general provisions here, so I won't go over that again. I'll simply start by swearing in the parties and taking testimony. Before I do that, I'll begin by, similar with that other case, going over my understanding of the record so far. And that is that, well, I think Ms. King hopefully will be able to fill in some gaps here. I have read everything. My understanding is that there is the parties here don't live in the same building, but live in buildings near each other. And there was an incident on June 1st that has resulted in petitioner Adrian Boyce being prosecuted in Thurston County Superior Court for harassment with Mr. Vassar as the alleged victim. So I want to be very careful, and I want to make sure everyone's aware. I know we don't have Mr. Boyce with us, but this is a hearing that's I put folks under oath. And so what is said here can be used in the criminal prosecution. And that includes anything that becomes inconsistent. And it includes, I know Mr. Boyce again isn't here, so there's no Fifth Amendment self-incrimination issues. But I want to make sure everyone's aware that it gets really tricky when the subject of a civil anti-harassment order is also the subject of an ongoing criminal prosecution, particularly where we don't have defense counsel kind of as part of it, because this could have significant impact on that criminal case. So that is currently pending, and my understanding is Mr. Boyce is also in custody on that right now. There was an incident there. Ms. King is alleging that part of that incident involved Mr. Vassar displaying and aiming a firearm in the presence of children, and then that's the basis of asking for a protection order. There's been some other documents filed by Ms. King that I'd ask her to maybe flesh out a bit. There's a lot of conclusory statements about child safety and things of that nature, but it's a little unclear from what's been filed. What are the allegations against Mr. Zachary Vassar? And I also want to be clear here that with Mr. Boyce having not been part of the petition and is not here to give testimony, I don't think I have grounds here to protect him in any kind of protection order. That would need some sort of testimony from him one way or another. And without that, I don't know if there's much I can do there as well. So I guess there's a couple of moving pieces here that make this hearing a little challenging. But with that, we've got the parties present. So Ms. King, I'll start with you and put you under oath. Again, I think it would be helpful to flesh out a bit what you're alleging occurred, and specifically why you're asking for an order against Mr. Vassar. So with that, ma'am, if you could please raise your right hand. Do you swear or affirm that the testimony you're about to provide is the truth and the whole truth?
Yes, Your Honor.
Okay. All right. Go ahead.
So this started on May 20th over kittens that I couldn't care for anymore. I had called the animal control to come and get them. They didn't answer. I left a message. They didn't call me back. I'd asked my fiance, my child's father, it was me who asked him to put them in the woods because I couldn't care for them. Our house was starting to smell like feces. I have 3 kids, yada, yada, yada. And so as he was putting them in the woods, Mr. Vassar came out and told him he's going to get him for animal cruelty, a felony for animal cruelty. Hold on real quick, excuse me. And he was harassing him about the kittens. Every time Adrian would go outside, Adrian would come inside frustrated. Here's her socks. Every time Adrian would come inside frustrated that Mr. Vassar was harassing him and commenting on the kittens. Well, June 1st rolled around and we were looking for our daughter, Riley. Riley was missing. I have walkie-talkies for the kids. She wasn't answering the walkie-talkie. She wasn't around my 14-year-old, so we started yelling for her. My toddler wanted to go outside with him to look for Riley. When he found Riley, Riley was in the vicinity of Mr. Vassar by the picnic tables and the trash can. And I don't know the extent of the conversation that it right then and there. I know what my 9-year-old told me was my toddler went to go pet his dog. His dog was growling at my toddler. And Adrian said, to the extent, get your dog before someone gets hurt. And our 9-year-old had already been bit by a dog 2 years ago, a pit bull. She had to have 15 stitches. So we're very protective of dogs and our children. At that moment, Zachary Vassar is on. I have the report, the police report. He pulled out his firearm and held it at Adrian's leg. At first he held it at the ground, the report says, and then he held it up to his leg. My toddler is knee height. I'm not going to say what either of them said because I was not there. But my 9-year-old said, Adrian said, get your dog before somebody gets hurt. Now that wasn't extended at him. That was a general statement. After that, from June 1st to, I'm going to read the police report. It says subject at apartments threatened to murder RP and told RP that he owned a firearm. RP pulled his own firearm and the subject ran away. RP is waiting by the.
So you're going to have to distinguish who's
Mr. Vassar
the reporting party. Yep.
Mr.
All right.
Mr. Vassar called on himself and let them know what was going on June 1st. The other involved ran back to his own apartment. RP declined to provide his own apartment number. RP believes subject is trespass from location and a convicted felon. That's what I wanted to discuss too. He knew pertinent and very sensitive information about our household. I did not know this man's name until June 5th when my fiance got arrested. Possibly associates with buildings. Clarify, RP has holstered firearm on his 3 o'clock. RP advised that he will have hands visible for law enforcement when they arrive so they can disarm him if necessary. Then it goes on to describe what he was wearing. Front office saw the male subject. Subject lives at F building. They did not give his apartment number for Mr. Vassar. It goes to describe his description. It says reasonable suspicion for felony harassment. There is a Elizabeth that is in here as a report, also reporting that she supposedly had heard him say this. I don't know. I do know that Mr. Vassar put my children in danger is what I'm here for. My children were 9 and 2, and Mr. Adrian Boyce was unarmed. We do not own firearms. Yes, we are both convicted felons, and we are not allowed to own firearms. I let the police come in here and look for him on June 1st when this had happened. I did not know that a firearm was pulled out at Adrian at all, because Adrian had left to go look for his phone that day, but the police had came and informed me that Mr. Vassar had called himself and let them know that he had pulled a firearm out with children present. June the 1st through the 5th had, there was several times that they both had went out to walk their dogs, our dog, and he went out to walk his dogs, and there was some altercation of communication between them as well. I do believe that this is between two men that are having issues handling conflict. I do not believe that there is a reason for, I mean, this is over kittens. This is pretty immature of both sides, but it has came to the extent that my children, during the time that Mr. Vassar had returned home, on, it says in the report on June 5th, he was home from 8:10 to 10:53. That he supplied his screenshots of his location. My daughter was also missing again on June 5th, and between the time of 8 and 9 o'clock, we were looking for her, and she wasn't answering the walkie-talkie again. At 8:30, something had occurred I did not know of until, I will get to that until Monday morning. June 5th, she returned home about 9 o'clock and stated that Mr. Vassar was around the area and held her hand over her mouth, and held him by her and said, her by him and said, "Don't tell anything." Unfortunately, that was, I apologize. That was a child that was in trauma at that time. She did not give true facts. In fact, on Monday morning, we found out that she was exploited by 3 other little boys at 8:30 on video camera. And the school district called me, the police and the principal had called me to inform me of this. Adrian was on the phone with police department as he was getting arrested, because we were reporting her being missing. And he was reporting the what Riley had said Mr. Vassar had did to her. I don't know the extent of whether that is true or not. His proximity and close around my daughter, both incidences, has made me very concerned. And at this time, our children have been traumatized by Mr. Vassar and his allegations of my child's father threatening to murder him. When he had supposedly allegedly threatened to murder him, he was unarmed, and 2 children were next to him. Mr. Vassar he had all protection against him. And my children, at that time that he was arrested for felony harassment, there was no threat. They had found supposedly probable cause on June 1st. 5 days later had went by, and there was no altercation. He had not harmed him. There was some altercation verbally between the two while they were walking their dogs. My daughter was in a state of trauma when her protector got arrested, and that would have came out had we had time to talk to her and he had not got arrested. It would have came out that Mr. Vassar had in fact not held her against her will. What would have came out was what had happened with the little boys in the woods close to his apartment, actually. So my children are very much, Riley is very much traumatized, and just the harassment. He knew pertinent information about Adrian's leasing status. He knew our name. He knew we were felons. The fact that, to my belief, I'm not 100% sure, he works for the Thurston County Fleet. And I believe that this is selective policing. He called the police on himself and told them that he did this in front of children. My children were the victims of a firearm crime, And I believe that our safety, I mean, he's still not home. I believe our safety is, in fact, in jeopardy. My 14-year-old says she sees him up at the park, the field, every time she goes to pick up her sisters from daycare about 6 o'clock in the evening since Adrian has been gone. And I don't know this man, and this started over some kittens, two men that can't handle conflict. They both should have minded their own business. But my children are, in fact, I feel my children are in safety. Our safety is in jeopardy, and I would like a continuation of this if possible.
Okay. All right. Thank you, Ms. King. I'm going to hear now from Mr. Vassar. All right, sir. You can please raise your right hand. Do you swear or affirm the testimony you're about to provide today is the truth and the whole truth?
I do.
Okay, go ahead.
So, at noon on May 20th, 2026, I was walking my dogs in a wooded area adjacent to my apartment. As I was walking, I saw a cardboard box with a plastic tote lid on top of the box just off the pathway. As I approached the box, I noticed a kitten with its face pressing up against a tiny hole in the side of the box. I immediately turned around and took my dogs back to my apartment. I then returned to the box of kittens and lifted the lid to find 5 very small kittens with no food, water, and they were covered in their own waste. The kittens had no way to escape the box. I then took the box to the office of my apartment and gave them food and water. With the help of my apartment manager, we were able to find and adopt them through social media. We were able to find them new homes through social media. After about 2 to 3 hours, all of the kittens had new homes and could be properly cared for. My apartment manager checked the security cameras at the complex entrance. The footage shows Mr. Boyce and his daughter carrying a box of kittens towards the wood there. My apartment manager and myself filed a complaint with Joint Animal Services and provided them with the footage. The report was filed by my apartment manager, as at the time I did not know the identity of Boyce. I was listed as a witness in the report. At this point, everything that could be done had been done, and that was the end of it. On June 2nd, I received a call from Animal Services, an Animal Services officer, and was told that there would be no charges filed against Mr. Boyce because it was considered a misdemeanor, and the prosecutor would likely not pursue charges, even though she said that the video evidence was some of the best she had ever seen in an animal victim case. I was disturbed that this person was not going to be held responsible for dumping the kittens, but thanked her for her time and did the call. Note that I had never met, seen, interacted with, or had knowledge of this person prior to discovering the kittens and seeing them on footage. The phone call with the officer was the last time I had any interaction with anyone regarding this. On May 23rd, 2026, I noticed Boyce at the entrance to the wooded trail where I found the kittens. He appeared to be looking to see if the box of kittens was still there. I approached him and told him that I had rescued the kittens, that he was on camera carrying the box toward the wooded area, and that I had reported him to Animal Services, and that he needed to leave the property. Boyce does not reside on this property and has no reason to leave. We engaged in a brief exchange of words and then went our separate ways. This was the very first interaction I had with Boyce. At the time, I didn't even know his name. On June 1st, 2026, at around 8:30 p.m., my girlfriend, Allie Elliott, and I took our dogs for a walk. After the walk and picking up after them, we made our way to the dumpster located by our front office to dispose of it. As we rounded the corner of the building, Boyce and 2 small children were standing on the opposite side of the building next to the side of the dumpster. After I made eye contact with Boyce, he turned to the older of the 2 children and said, "F that dog," referring to the small chihuahua whose leash I was holding. They then walked around the corner of the building towards the front of the dumpster. After a second, I cautiously continued towards the dumpster so I could throw away the dog waste. Boyce then said, "F this guy, I'm gonna murder this guy." As he was saying this, he was rapidly moving one hand around his waistband, while the other hand was still holding the smaller child's hand. I immediately felt threatened and concerned about my girlfriend's safety, and I drew my firearm, keeping it lowered by my leg and pointed at the ground. I told him he was not even supposed to be on the property and verbally reiterated that he had just threatened to kill me. I again told him he should leave the property. Boyce responded by saying, "F you, I'll murder you, fool. You just made a big mistake." He then said, "Oh, I got something for you at the house." Because Boyce continued to threaten me, I raised my pistol to a ready position and told him once more to leave the property. Boyce then turned to the older of the two children and said, "This is the fool who saw us on camera," referring to the incident of him and the child in the process of dumping a box of kittens in the nearby wooded area on May 20th. The child responded by flipping me off and saying, "F you." Boyce and the child then turned and started to walk away. Because the immediate threat seemed to have passed, I reholstered my firearm and walked over to see which direction they were heading so I could relay that information to dispatch as I was in the process of calling them. Dispatch advised me that it would be safer to wait for officers inside of our apartment or wait from the scene if Boyce decided to return, so we went to our apartment tour. After our officers arrived and conducted their investigation, they concluded that they had probable cause to arrest Boyce for felony harassment with threats. The officers were unable to locate Boyce to make the arrest at the time. I submitted this statement and evidence to the court, and further details are within that Exhibit C of the police department case. On the evening of June 5th, I received a phone call from OPT Officer Perez Gutierrez. He asked me where I had been that afternoon in Hogan. I was slightly taken aback by the question, but I told him where I had been during the time frame he mentioned, which was the family birthday party held at 30 Days Pizza Parlor. He thanked me for the information at the end of the phone call. At that time, I had no idea why he had asked me about this information. I later learned that Boyce had accused me of holding his daughter against her will and not allowing her to communicate with her parents via walkie-talkie. All details of this fabricated incident can be found in Exhibit D of my evidence. I will add that I provided my whereabouts to the officer via Live 360, which is an app that tracks your location via your phone. Additionally, I was with 5 members of my family and my girlfriend in a public restaurant. In the OPD report.
Hang on, Mr. Vassar. If you could hang on for one moment. Did we lose Miss King? I just saw a message that she's okay. My compute. Okay. She says my computer's glitching. I can sign on and off when he is done with his testimony.
It's not letting me, it's glitching. I can hear part of it, but it's on, I have CC, closed captions going, but I don't know if it's showing me or not because on my side, it's showing that it's blank. So I just wanted to update you of my status. I can read what he's saying, but I cannot hear him.
Okay. So you cannot hear Mr. Vassar? Is that right, Ms. King?
Or I'm reading your closed caption. I can't hear either of you.
Okay. All right. If that's the case, I don't know if closed captioning is accurate enough to rely on here. And it's also, Mr. Vassar, you glitched a bit on our end too there for a moment.
Okay, I could go back and.
Well, my concern is I want to make sure everyone can hear everything, and we're getting connection issues on both sides here. I'm partially inclined to reschedule this to next Monday and have folks come in person so that we don't run into this technical issue. Yeah. Okay. So, Ms. King, just to verify, you're saying you cannot hear either the court or Mr. Vassar at all and are instead relying on closed captioning. Is that right?
It's going in and out. I can now. It's going in and out. I can hear most of what you're saying, but it is glitching. That's why I asked if I may log off real quick and then log back on to reconnect.
All right, let's try that. And if that doesn't work, I think we're going to reschedule to next Monday and have folks come in person.
Yes, sir.
All right.
One moment, please.
All right, we'll hold off and let Ms. King try to log back on, and then Hang on, Mr. Vassar. We'll just hold off till she's back and then see if we can finish this today.
I'd just like to add that we have not had any connectivity issues whatsoever.
Okay, thank you for letting me know. All right, so Ms. King, we've got you again. Yeah, if you could, I know you had your camera off before. Maybe if you keep it off, that might help with bandwidth.
Oh, okay.
Are you able to hear me, or are you seeing this through closed caption?
Nope, I can hear you. I can hear clear now. I had to plug it in and log back in online, so the connection is good and it's charging. Thank
Okay,
you. I apologize.
Nope, that's all right. We want to make sure everyone can hear everything. And Mr. Vassar, on our end, it was just one time glitch, so hopefully we're okay moving forward. You can continue with your testimony, sir.
Okay. So I believe I stopped. I will add that I provided my whereabouts to the officer via Life 360 app, which is an app that tracks your location via your phone. Additionally, I was with 5 members of my family and my girlfriend in a public restaurant. In the OPD report, Exhibit D, the officer describes how when questioning Rayleigh about the incident, Boyce was clearly coaching her responses. After hearing Rayleigh's story, the officer arrested Boyce for the incident of harassing and threatening to kill me. When the officer started to put restraints on Boyce, Rayleigh came at the arresting officer with a steak knife. The allegations that I was somehow involved with the child being unaccounted for or missing were deemed unfounded. I was relieved that that he had been arrested, and I was glad that the situation was over and I could get back to my normal life without the stress of not knowing if Boyce was hanging around my apartment complex and I might encounter him again. King later called dispatch to inform them that she had spoken with her daughter and she was not able to confirm if Rayleigh was telling the truth or not. However, King said she believed the report Rayleigh read was not accurate. Due to the inconsistencies throughout the report made by Rayleigh, Adrian, and King, this case was unfounded, and that was OPD case 2026-0312. On June 12th, 2026, my girlfriend and I woke up to the sound of someone banging on our apartment door. I answered the door to 2 police officers who introduced themselves as OPD and asked if I would come out and speak with them. I asked them what it was regarding, and the officer said that I was not in trouble, but that he was here to serve me with papers. I was confused and asked what the papers were about. He told me that it was an anti-harassment order from a Valerie King. I was even more confused because I had no idea who this person was. I asked the officer who the person was. The officer asked me if I knew an Adrian Boyce. I said that I did, and I told the officer that I currently have a pending protection order against him for felony harassment and threatened to kill him. The officer then told me that King was Boyce's girlfriend and the guardian of the children that Adrian was with on June 1st. I asked a few more questions, took the papers, and went back into my apartment. I read through the papers where King says the incident with Boyce caused fear for her children and household. Those are the same children that one of them was flipping me off and telling me to F off during the incident. King also states that before the firearm incident, Vassar repeatedly confronted or antagonized Adrian about the kittens after animal control had been contacted. I had never repeatedly confronted or antagonized Adrian Boyce. Before the incident where he threatened to kill me, I had only ever spoken to him once, and that was the time when I told him he had been reported for dumping the kittens and that he needed to leave the property. I do not know, nor have I ever spoken to Valerie King or her children. I wasn't even able to provide sufficient information to the police about Boyce's residence because I have no idea which apartment number he and King lived. I don't even know what King looks like before today's hearing. The only threats in all these situations were made to me. The harassment is being done to me. The other false accusations by Boyce and his daughter were serious and completely fabricated. Other alleged incidents mentioned in the protection order are also untrue, and some even contradictory to the apartment security footage that I have provided, such as the allegation that my girlfriend's dog growled at King's top. The footage clearly shows the dog on its leash at least 6 feet away from the child, and it wasn't even barking. I would also like to emphasize that all of the claims in the protection order are false and at odds with the facts presented in 2 different Olympia Police Department reports. All interactions I've had with Boyce have been on the property of the apartment complex where I reside. The only time I've seen Boyce's children is when they were with Boyce at my apartment complex. I've never had interactions with the children except when Rayleigh told me to F off while flipping me off, which I did not respond. Adrian Boyce was.
Mr. Vassar, if I think at this point I think I understand what both sides here are getting at. And just so everyone's clear, I'm really focusing my attention on a single act of violence prong. I understand there's been allegations. I guess some now have been taken back, but there's still some questions out there. As far as the kind of the incidents with the kittens, and then the incidences on some of these allegations, I'm not really finding either of those to be substantiated enough or relevant to what's before us, which is a request for an anti-harassment protection order and an order to surrender weapons. For that, I'm really focused on the facts that are underlying the criminal prosecution. So I understand this can be this is a bit tricky, but we don't have the Mr. Boyce present again with implicating the Fifth Amendment. But I do find, to the extent that there's some sort of allegation forming the basis of what could be an order, that's it. So Mr. Vassar, if we could back up a bit, and then I'm going to turn back to Ms. King as well to hear from her on this. But out of everyone here, you were the only one present. So can you go back and describe for me again the incident where the firearm was pulled? Because it sounds like you sort of articulated what happened there. And I heard it all. I think it's important to go back over that maybe one more time.
Okay.
So yeah, if you could go back over that again for me, sir, I'd appreciate it.
Okay. Okay. So on June 1st, 2026, at around 8:30 p.m., my girlfriend, Allie Elliott, and I took our dogs for a walk. After the walk and picking up after them, we made our way to the dumpster located by the front office of our apartment complex to dispose of it. As we rounded the corner of the building, Boyce and 2 small children were standing on the opposite side of the building next to the side of the dumpster. After I made eye contact with Boyce, he turned to the older of the 2 children and said, "F that dog," referring to our small chihuahua whose leash I was holding. They then walked around the corner of the building towards the front of the dumpster. After a second, I cautiously continued towards the dumpster so I could throw the dogs. Boyce then said, "F this guy, I'm going to murder this guy." As he was saying this, he was rapidly moving one hand around his waistband, while the other hand was still holding holding the smaller child's hand. I immediately felt threatened and concerned about my safety and my girlfriend's. I drew my firearm, keeping it lower than my leg, and pointed at the ground. I told him that he was not even supposed to be on the property and verbally reiterated that he had just threatened to kill him. I again told him that he should leave the property. Boyce responded by saying, "F you, I'll murder you, fool. You just made a big mistake." He then said, "Oh, I got something for you at the house." Because Boyce continued to threaten me, I raised my pistol to a ready position and told him once more to leave the property. Boyce then turned to the older child and said, "This is the fool who saw us on camera," referring to the kitten incident. The child responded by flipping me off and saying, "F you." Boyce and the child then turned and started to walk away. Because the immediate threat seemed to have passed, I reholstered my firearm and walked over to see which direction Boyce was heading so I could relay that information to dispatch. as I was already in the process of calling 911. Dispatch advised that it would be safer to wait for the officers inside of our apartment, away from the scene, in case Boyce decided to return. So we went to our apartment to wait. After officers arrived and conducted their investigation, they concluded that they had probable cause to arrest Boyce for felony harassment with threats. The officers were unable to locate Boyce to make the arrest at the time. And that was the incident.
All right. Thank you, Mr. Vassar. Going back to you, Ms. King. I know that I believe you had the police report, which I don't have in the file. I believe you were referring to that earlier, though. Again, the rules of evidence don't apply at these hearings. I'm curious, Ms. King, your kind of on your end of it, what would you like to say about the alleged incident? I know you weren't there, so you're kind of basing this off of what you heard from Mr. Boyce and from the children. But go ahead. I'll let you describe what your understanding of that incident.
Yes, Your Honor. Thank you. As I mentioned, our child was missing, and I do want to note that case number 2026-03170 is unavailable right now because it is still under investigation regarding children. And that was founded where she was missing because she was on video camera on another child's phone. So that is not available to anybody right now. That was on June 5th at 8:30 p.m. On June 1st at approximately 9 o'clock p.m. Riley was at 8 p.m. We were looking for her again. She was missing. She wouldn't answer the walkie-talkie. Excuse me, this was about 4 o'clock in the afternoon. It was not dark yet. And Adrian had went out with our toddler. She wanted to go out there with him because he was leaving. When they went outside, he found Riley around the, on Fern Ridge property by the picnic tables, which is by the dumpster. And Riley had asked to pet the dog, and Adrian had told her no. And the dog was growling at Javaya, our toddler. And he said, "Get your dog before somebody gets hurt." It's my understanding from my 9-year-old. I am also going off the police reports. There is no exact statements on these police reports exactly what Mr. Vassar had said. He just said it was threatened to murder him. There's no exact statements on here. Adrian Boyce was an unarmed black father with 2 children next to him. Regardless of what Adrian did or did not say, my children were present. Adrian was at that moment unarmed, and Mr. Vassar did pull out his firearm and aim it at Adrian's knee in the same vicinity as my toddler's head. If something had glitched with that firearm and something had happened, we would not be in this situation. It would be a grave situation, unfortunately. Thank God it did not happen. It sounds as Mr. Vassar is very fully aware of his, knowledgeable of his firearm. But at the same time, I don't know that. I did not know that then, and I only just recently finding that out. My children they're traumatized. They thought their father was going to get shot. They've never seen that before. And he still could have called police without pulling out his firearm if he felt that threatened. 5 days later, he gets arrested. There was no threats of violence during that time, except for Mr. Vassar and him knowing inaccurate information about Adrian, which he is, in fact, a resident of Evergreen Vista, not Fern Ridge. I don't know why he would feel the need to pull out a gun with 2 children present. That to me, I felt that it was by any means necessary to intimidate Adrian, to get leverage of the situation between 2 grown men. I just want my children to be safe when they're outside playing, and I would like Mr. Vassar to no longer in itself with our household. Of course, there's a criminal investigation going on, but I would like him to mind his business and no longer insert himself into our household.
Thank you, Miss King.
Thank you.
I appreciate it. And well, I'm not regardless here, it sounds like what everyone is agreeing is there was an incident at some point where, a gun was displayed and aimed and there was children present. So I hope your kids are doing okay. I think that's, regardless of my ruling today, that's certainly something that's difficult for a child to go through. As I said before, what I'm finding that if there is to be an order granted in this case, it would need to fall under the single act of violence prong of the unlawful harassment statute. And I sort of hinted at this earlier. The elements are largely the same as traditional unlawful harassment. The difference is that first element, whereas unlawful harassment will typically require a knowing and willful course of conduct. To qualify under a single act of violence, there needs to be a single act of violence or threat of violence, and then directed at a specific person that seriously alarms, annoys, harasses, or is detrimental to such person, that serves no lawful or legitimate purpose, which would cause a reasonable person to suffer substantial emotional distress, and that actually causes substantial emotional distress. And again, in this case, in the presence of a firearm or other weapon. To me, this all boils down to the element of whether the display of the firearm by Mr. Vassar, which seems to be undisputed here, served a lawful or legitimate purpose. And the context I'm looking at this in is it is the petitioner's, Ms. King's, burden to show more likely than not that Mr. Vassar's display of the firearm served no lawful or legitimate purpose. And that argument is being made in the context of Mr. Vassar being the alleged victim in a case where Mr. Boyce is being prosecuted for felony harassment from the same alleged incidents. Now, this is not that case. I'm not making any findings of fact about that case. We don't have Mr. Boyce even present. The question is, the only relevance of that in this case is whether there is proof by a preponderance of evidence that Mr. Vassar's display of the firearm did not serve any lawful or legitimate purpose. And given the context of the criminal case as well as what's in evidence right now, I can't make the finding more likely than not that Mr. Vassar's actions here were without legitimate or lawful purpose. That's not to say that they were or they weren't. I can't make a finding in order to issue an anti-harassment protection order based on what's before me. I think it's an open question, and on balance then, because it needs to be more likely than not, I can't make that finding. And so, Ms. King, the orders being denied based on that determination. Do you have any questions, ma'am?
No, Your Honor, I do want to make note that there is a further investigation with the Olympia Police Department with Lieutenant Whining, as well as the OID regarding this case, and all elements of all three cases involved. So I do want to make note that there is further investigation going on, and I have contacted and been in contact with the lieutenant, and he is doing his depth research and requesting all files, body cams, and of that nature as well.
Okay, understood. Thank you, Ms. King. Mr. Vassar, do you have any questions?
There is, I guess I don't have any questions now.
Okay. Yeah, to the extent that I know there was a temporary order that was issued that expires today. So that simply is not converted into a full order. So that temporary order goes away. There's nothing further that needs to happen for that order to expire.
Okay, thank you, Your Honor.
All right. Okay. Thank you all for your time this morning. And you're all free to log off.
My dogs may start barking. The fox has been seen running across my driveway, and they are annoyed. Ladies and gentlemen, They're almost as annoyed as some people in Washington State. They're almost as annoyed as Judge Stevens. Look at that one right there. Fresh coming back from the battle zone. I don't know how they know there was but it's a pretty fox running right across my driveway. Just in case anybody out there is interested and wants to know, we're joining Hutch coming up right next. Rhonda, you put a link to it, but I forgot all about what is it all about? Hold on, ladies and gentlemen, I'm doing that thing where I look up information that I should have known long. Can AI win your court case with 20 plus motions? That is the question that has been posed by Hutch's video that is going to be a fairly long one from what I understand. So that's the reason we're ending early tonight and passing the ball over to him, because he's got a long, interesting one that I kind of want to see myself. So, yeah, we're doing that, kids. And before we get to doing that, I'm going to hit that button, come over here, and hope my, hey, there, it works. X25. Kitten. Wait, where's my thing? Why is all of my tools, every time I go look for thank you, X25. Natasha Kitty, Northwest. Natasha Kitty again, and Cosmic Sheldon. Loved seeing those little jewels and things. Those were fun, right? And great to see our friend OSG, the OG Old Squishy Gardener. Happy to have you out there, and so happy to have Colin and the crew in the house tonight. Thank you for the raid. That was very kind of you. Ladies and gentlemen, I am your lone Wafoosel. I find these little court nuggets all over the place for you every single day, and I bring them to you for little get-togethers just like this one, where we talk about what was going on in the chat, and it's always an interesting chat. Yes, it is. But for now, we're moving on down the line. We're gonna go hang out with Hutch for a while. See, his video should be getting started in just about 1 minute from now, so I'm kind of vamping. You know how I do. I do what I do. I hear OSG's been a little under the weather out there. We hope he's getting a lot better, a lot faster. Not gonna hound him about it or anything. We've just been missing his content because, God, he's got some of the best content out there. For anybody who's not a wolf in the court sphere, right? He is the best court watching gardener in all of YouTube. The best court watching gardener. I'm the best court watching wolf. That's all there is to it. For now, until the next wolf time, same wolf channel tomorrow, I'm your lone Wafoosel, and I am out. And I can't vamp too much for the after, the little post show thing, because we gotta hang out with Hutch. I got nothing else. You gotta go now. Go. Hutch is waiting for you. I'm positive Rhonda put links like in the chat like 100 times. Get out of here. Love you. We'll see you next time.